Yes.
You're waiting for a policy person?
Yes.
Okay, here she is.
Okay.
Good morning, it's Linda Clemens.
Hi, Linda. I'm calling. We're trying to find how we can get information about the policy for Child Protective Services in North Carolina, and who we can talk about, who we could talk to about some reports that are coming in from different counties about how Child Protective Services is operating.
Okay, give me a little more information. Are you calling from another state?
No, I'm calling from North Carolina.
Okay.
I'm with a new nonprofit organization called PALS, and we have several reports from several different counties about child removals, and so we're just trying to get information because what it sounds like, or is there a written, I guess you guys have that policy online, but we're getting reports from the different counties that children are regularly removed without hearing prior. They're supposedly removed by court orders, but no parents are getting copies of the orders. We have one gentleman who has the whole removal on video where they say they have an order and then they don't have an order. Then they admit they don't have the order yet. The 7-day hearing.
Okay. Good.
Sorry, for just several different things that we're confused about.
Because we can, in certain circumstances, take a child into custody on a 12-hour hold, not having an order in our hand yet. But that should be established, and that's not an individual worker makes that decision along with their supervisor. It's not done very often, but normally there is an order, but the hearing is not immediately. It's usually a 7-day hearing. Let's see, but I'm jumping around a little bit too because you've got a lot of things you're trying to figure out. Let me find the new website is not the easiest to maneuver around. So let's see. I personally don't even go there through the main website. I have a link that goes right to our manuals, but they're not. We're actually in the process of rewriting our manuals, so they're much easier to follow and read. I can direct you to those, but they're not, like I said, the most easy to follow. How can I help you best, I guess?
I realize that after I start talking that there is some online manual. I guess, okay, just on these two topics that we were talking about, the reports that we're getting is that, and we have testimony too, where we know they can take a child if there's not enough time to get a warrant or a court order without the order and then get the order later. But I think the problem is that the workers believe, or the different separate counties believe that if it's, there are instances where it's not an emergency and they're not holding hearings prior. They're still getting a court order when the child is not in any immediate danger, and they're still removing the children without hearing, claiming to have these non-secure custody orders. And then the 7 days.
There is no hearing before we take custody. But at least, because there's supposed to have a child and family team meeting. It's not an emergency. You sit down and talk to the family about safety planning. But the orders that are signed by a judge are not usually you don't actually have a hearing. They're signed by a judge, but isn't an actual sit-down hearing to get that order.
Aren't those supposed to be gotten, though, still, if you don't have a hearing, if the child is in an immediate danger of physical harm or sexual abuse?
No, anytime we get a non-custody for an order for custody, whether it's neglect, abuse, dependency. It's just one kind of non-secure custody order, and there is not a hearing prior to issuing that. It's there's supposed to be a 7-day hearing after that, but there is not a hearing prior to us taking custody, and it doesn't matter what the circumstance is.
And that's the problem that we're having, because the 7-day hearings as well, the different agencies are treating them as hearings just to review the placement. I've seen the policy manual where it says a hearing on the merits or a hearing to review placement. It seems that every single county that we have reports from, anyway, assume that the 7-day hearing is just to review placement. So what's happening is that any allegation, they're taking the children without a hearing. The parent has no chance to defend themselves. And then they have the hearing 7 days or just as soon as that they can have it. And again, the parent is not able to defend themselves at that hearing as well. They're waiting till adjudication before, and I mean, I even have the program managers, the different social workers all saying the same thing. They think the 7-day hearing is just to review placement. It's not allowing the parent time to testify, to deny the allegations, to prove them wrong. Then they wait for adjudication. Adjudication is taking months. The program manager I last spoke with said they tried to do it in a few weeks, but 30 days is the earliest that we've seen them. And then on top of that, at those, they're bargaining with the parents, saying, we'll give you your kids back if you stipulate. So basically, they're not giving the parents any hearing or opportunity to defend allegations. And they just taking children when they're not in any kind of emergency. The parents aren't getting any kind of hearing the way that it's set up now.
Well, some of what you're talking about, I can totally understand how that would feel to a parent, and that is how what you're describing actually is pretty accurate and is what happens and is legal. I don't know how to put it in different terms. Let me walk through this a little better. So when we file for a non-secure order, that there is no hearing, we get a judge to sign. Hello?
Yeah, I'm here. Sorry.
Okay. I must have another call trying to come in. That's fine. And then they have the 7-day. And the 7-day hearing is supposed to make sure there was just cause, but it is not a hearing that has testimony that the parent really feels like they can defend themselves. It's pretty much it. What I tried to do is help parents understand that the 7-day hearing is somewhat similar to your first hearing in criminal charges, that you have a right to know what your charges were. You have a right to get know that you have a defender assigned, or you get to find out if you qualify for a defender. But it isn't actually a hearing regarding the allegations. That is the adjudication hearing, which is unfortunately does take a while, and it's supposed to be in the 30-day time frame. I think it's supposed to be a minimum of 6 weeks, but oftentimes, unfortunately, is continued. And what you're talking about as far as stipulations, every parent has the right to request a trial. It kind of depends on how their attorney presents it to them. That it may feel like a negotiation, but they still have the right to have a hearing if they don't think that it's appropriate. But I totally understand how, depending on how it's presented to them, what you're describing isn't totally how it would feel. I don't know the answer to any of that really well.
We have it in writing where the court appointed, and see, it's because it's a child involved. The court appointed attorneys for the parents that we have reports for. Assume that they have to cooperate with Child Protective Services. Everybody assumes they have to cooperate, and so they're actually advising parents. I mean, I have one where the lawyer says, hey, we'll have a trial for a year, or you can have your child back in 4 weeks. And if you stipulate, I have one lady who they won't give her child back at all. They don't have any reason to keep her because she won't sign a case plan. I don't know what that's about. Doing a case plan versus signing a case plan is two different things, in my opinion. I thought there would be some kind of protection, because it's like anybody can make an allegation, you know? Anybody can make an allegation. They may not be true. To take a child from their parents for months at a time and have no hearing on it doesn't seem like it would. It seemed like it would violate the Constitution, even, you know, basic human rights. I don't know. Changing
the
that.
attorney has the right to see the file, and the attorney has the right to that proof that it's not just based on allegations; it's based on findings that something actually occurred. So that's part of the issue too. If the defender, their attorney is not appropriately helping them out and looking at the information and communicating to them that this information exists, then they're not getting what they have the right to get. Because a petition, custody is not, a judge won't sign a custody order that is just based on allegations. It has to be based on findings that support those allegations were indeed accurate.
Okay, well, that's not what we're seeing is social workers manipulating petitions and then the judge just signing them. I mean, I've seen petitions that don't say anything. They don't have any proof. Or there's ones where the only proof is the social worker is swearing to the accuracy when they're not accurate, and then and they're getting signed somehow by judges. Like there's no protection here. The social workers have it in their mind they want to take the child, so they word the petitions any way that they choose in order to make that happen. And we don't know where we can go to help these parents. I mean, we have one lady whose child has been in and out of the hospital since being taken. She's losing her mind, the child is. I mean, it's documented in an email from social workers, and she cannot get anybody to help her. And the only thing they're telling her to do is to sign a case plan, which she's scared to do. I don't know. We also have, before I figure out who we can speak to about this, but what about, there's another issue with ex parte cease to obstruct orders. That we're being informed that they can be filed when any allegation is made and the parent refuses to let the worker in the home and to see the child. Even if there's no corroborating evidence, just an allegation made by phone to a hospital.
The law states that we have to investigate an allegation. The only way we can investigate and assess the safety of a child is to be able to see them and talk to them. If we can't get access to them, we cannot assess it. That's the law. So there is what's called an ex parte for a parent that refuses to cooperate to allow us to assess an assessment, an allegation.
But let's say that it's an anonymous call. We don't know who.
Doesn't matter. We have to assess every allegation, and that's what the law says.
But see, federal law says that that's actually not. I believe the North Carolina State Supreme Court also stated that there has to be some corroborating evidence. It can't just be an anonymous phone call in order to, because that's a Fourth Amendment right to not have government.
The law is the purpose of the law is to balance both the child's right and the parent's right. So that's a lot of what we spend time doing, and that's why all attempts are made to work with the parent to explain what we need to assess. But that's a lot of what the difficulty is in child welfare, is balancing those rights. And there's really no way to assess if a child's safe without seeing them. And we have no way, just because a call is anonymous, that doesn't mean it's any less appropriate. It could be someone that's fearful of retribution, and it may be a very true report. Just based on whether it's anonymous or not, we cannot determine whether the validity of it or not. So we have to respond to every report that we receive if it meets the definition of abuse or neglect by the statute. And that's what we're following the law and trying to make that assessment.
I mean, I'm sure. I wonder if you could appreciate this. So I don't know. I imagine that a lot of people call and make reports, though, like out of vengeance, things like that.
I think you'd find that it's not what people think it is. There is data at the Jordan Institute for families under UNC that tells where most reports come from, and over 80% comes from between either schools, other human services agencies, or the police, and over 80% come from professionals. And then you get into neighbors and relatives. The anonymous reports aren't nearly as many as you may think it is.
Maybe you know this. Then, statistic-wise, is there any statistics though on how many people report abuse that actually end up being the ones who care for the child? That's another concern that we have, is that a lot of people call. It's almost like ordering a child. They're like, hey, this child is abused, but we'll take care of that child.
Well, I know that there is data regarding if you file a report, and I can't put my hands right on it immediately, that starts a report from the report made all the way through the case. For instance, I think North Carolina, it's somewhere like all reports made, less than 5% come to the point where we take custody. So the rest of them are either a certain percent, 20% are screened out before we even do anything, and that percent's not accurate. I'm just throwing a number out there. And then based on those, another 50% we find out that services, they're not true, or the services aren't needed. They might have an issue we can help them with immediately, and then bow out. So I think it's somewhere around the calls that come in, only 20% even get referred for ongoing services, even within home and or foster care. And less than those, and like I said, only 5% come into custody, less than that. And I don't know the exact numbers, but I know that's, somewhere on the ballpark. So people really don't realize that of reports that come in, very few do we actually become long-term involved with. Does that help a little bit?
Yeah, I couldn't find any of the statistics. The ones we found were just,
that's a good question. I don't know that it's usually grouped like that. I think you can go on different websites, like at the North Carolina Jordan Institute. UNC Jordan Institute has things about how many reports come in per county, and then it can tell you how many children are actually in custody. That's two different numbers. You have to be careful. The reports come in by family. The number of children in custody is by children, so that could be, only maybe a third of those are different families because they come in sibling groups. So you can't directly correlate number of kids in care to the number of reports because it's a subset of that. But you should be able to find at least, I don't know, if that Jordan Institute information is public accessible.
I don't know if I've seen that. I've seen some things from UNCW, but I just have one more question. If by chance it happens that, because it's just the one social worker that actually has contact with the family. I know they changed when the one that removes the children. Let's say that one worker is not honest. That worker is dishonest. The concern is like there's a male social worker who has contact with the family. He writes the report. He reports to his supervisor. He writes the petition. He picks the child up and has sole access to the child. He could be a pedophile, is where I'm getting. The man could be a pedophile social worker, and he has direct access to the child completely. At all times, he can go get her from the daycare. When the child is removed, he has the child by itself. When the child, after the child is removed, he picking up the child from daycare, and let's just say that there's proof that he lied to take the child. What can a parent do in a situation like that where there's a social worker who has gone rogue, who could be potentially dangerous to children in the future?
Well, I think you can always go up the chain of command. I know that doesn't always feel comfortable to parents. Most counties have some kind of complaint line, and the state also has a place that reports can be made. And I know I'm not in that section. I'm in that same department, but I don't respond to inquiries that come in. But I know that there's two people in particular that take all kinds of community reports and will follow up and do an independent from the state aspect and look at the county and listen to the parent or whoever has a concern and follow through to get both sides of that information. I actually haven't followed that through the end to find out what the outcome is, but I do know that we have found concerns and we have followed up on them. I cannot say what kind of repercussions may or may not have come from that. I just know that there are some ways of making known that the concerns exist. And again, their defendant attorney, court attorney, should be helping them on that. So I guess there's a couple different ways: through the county, through the state, through their county, through their court-appointed attorney, or hopefully maybe they have their own. Although some of the court-appointed attorneys are very good, some of them are not so good. We all know that. Yeah, there's good and bad out there.
I don't want to. I'm not want to quick to blame the court-appointed attorney. I know most of these parents can't afford their own attorney. I've seen several cases where the parents, most of these parents were not allowed to represent themselves. They had to use a court-appointed attorney, and then it just can't be a coincidence that every single court-appointed attorney is telling these parents to stipulate at their hearing. There has to be something else going on, and we can't figure out who exactly to point the finger at. But I don't want to point the finger at the court. I mean, I do want to point the finger at them, but they can't all be telling parents the same thing. There's some kind of cooperation between them and DSS that they feel they have to do, and I don't know how we could address that issue as well. But they're all telling the parents the same thing, to stipulate and make plea bargains over their child, and it can never actually work out. And then I have a lady who called a state investigator. I'm gonna have to get the number for that person that she called, but that person basically laughed in her face and told her that I'm sure that's her perspective, and she wasn't really interested in investigating. It was very sad. So, and then the county department, complaints aren't going anywhere with them either. I mean, it's kind of like telling the criminal to investigate themselves. It's what problem we wanted to try to do something on the state level. Other states don't do this 7-day hearings. In other states, I mean, if a child is taken without a warrant, they have a 72-hour hearing on the merits right then. But you can write anything you want in a petition, have a judge sign it, and then the parent is screwed for months. They don't have any kind of hearing whatsoever. There's something wrong with that, and we really need to fix that.
And I don't think anyone would, at least no one I know, would disagree with that. And I know there are some counties, there is some state-initiated court improvement work that's going on, because there's certain counties that don't even have court hearings but twice a month, and that's a child shouldn't have to wait because they don't have hearings on the calendar. That's inappropriate. So I know there's some work being done to do that, and I know that the state hasn't passed some federal requirements because the court hearings haven't happened in a timely manner. So I know there's work being addressed. Some of that, it doesn't feel like that, I'm sure, to a particular child or parent that's sitting out there right now, frustrated. And I got nothing I'm going to be able to tell them about what's going to help them right where they are right now. I wouldn't want to be in any of those people's shoes. It's not a place anyone would want to be. I'm not sure. I'm kind of struggling with how I can best help you today. I can give you the link to the North Carolina manuals.
Okay.
If you wanted to look at those.
Yeah, that's fine. You've been a great help, because I just wanted to clarify. We were just trying to make sure that the counties weren't doing it wrong. What was going on? It was, but I guess the policies. Everyone is saying this is the policy. So
yeah, I think the hard part is that, and I'm not sure how to fix this. And this is something I struggled with when I was in the field. Is when you're trying to tell the parent this is kind of the process, to them you're the bad guy anyway, so they're not necessarily believing you. I don't blame them. I wouldn't necessarily either. And usually there is some material that's provided, but every county is a little different on how they support parents when this happens to them. And they really almost need like an independent little write-up of these are the steps and this is what the law says. And I don't know that exists in a nice, clean way, especially for some parents are more challenged than others to understand, especially when you're stressed. So even what they hear and what's being said isn't always the same, and it isn't always totally equitable. There's no way to say it is. I mean, I think we try to be, but I don't know that we're achieving that. But yeah, I think that would be a great improvement if there was something that could help from a parent standpoint. I know some counties have tried to put parent support groups together, but they've been very, very difficult to maintain. That a parent that's been through the process to help a new parent.
Yeah, that's sort of what we were trying to get in place, because, like you said, when that happens to the parent, they're immediately suspicious of the workers, and then. Mm-hmm. And then there you go. Then the workers, it's difficult to work together, and the child never ends up getting returned because of that difficult relationship between the parent and the worker right off the bat. Mm-hmm. And so, that's kind of what we were trying to do. But we're very small right now, so we don't have enough people to do that. But okay. Sorry, what was that website?
All right. Well, I'm just going to read to you where I am. Because
I might have it. It's for the Chapter X. It's the court one, right?
Chapter 10, court and child welfare, yes. And Chapter 8, protective services, yes, that's the one. Okay. And it's not easily written because it goes back and forth between what is policy and what's best practice, and that's part of what we're trying to make. Rewrite it so it's very clear this is what policy says and this is kind of what best practice is, because it's kind of intermingled right now, and it jumps around. It's not the easiest to follow, but as you read through that, if you find something, there are frequently links to the North Carolina statute that supports the policy, so you kind of have to jump back and forth to read statute and then back to policy.
I'm sorry. Let me ask you one more question. Do you know anything about reasonable efforts requirement? I have one where a child was taken, and under reasonable efforts, it says that parents obstructed efforts, so they took the child. Is that normally like policy? Does there have to be reasonable efforts prior to removing a child, or?
It depends on the circumstances, because there is the allowance for the safety is great enough that reasonable efforts were not, there wasn't time or ability to do that, but reasonable efforts usually includes, the assessment of the allegations, talking to collaterals, talking to providers, or there's usually holding meetings, whatever was done prior to take custody is what should be there. There is an allowance to say that the circumstances were such that reasonable efforts were not able to be conducted, and that could be an example of it, yes.
But would a parent non-cooperation be a reason to take a child?
Depends on how unsafe it is. I mean, if the child, if you have a doctor's report that says a child was sexually abused and the allegation says that dad's doing it and dad won't let you see the child, depending on the circumstances, it could be.
We're talking about drug test refusals or, what's the other thing? Background checks on everyone in the house, stuff like that.
I don't know this. I don't know enough about the specifics. So, under most circumstances, that may not be, but I don't know what the history is. I don't know if they had prior history, and this is a brand new report after having history. I don't know anything about the circumstances, and it is so case-by-case specific, which makes it hard because you don't want to say they can do it in one case, not in another, but they might have information that makes that a case. I mean, maybe, I don't know if the allegations that they're giving drugs to the child, I have no idea what's, the circumstances may be.
Okay.
Because unfortunately that's happened. Not very often, happily, but it has.
It's crazy, yeah. We don't have any parents like that yet. So.
Well, good.
Okay. You don't happen to have phone number for anybody that investigates specific workers or the county? Or?
I don't know that, I don't know that anyone has a process for that. They usually have a place you can, you can request a new worker on the case. Typically when it goes from the assessment to foster care, they get a new worker anyways, and we establish a working relationship with that new worker. A really small county that may not be possible, but typically, the case shouldn't come down to just one word against another word. There should be some supporting information, but it depends on the circumstances. Without specifics, it's really hard to.
We're not seeing that. We're just seeing we have supervisors, sure, but they're just signing off. They don't actually have contact with the parent. We've just got workers saying, hey, this is what I saw.
Yeah, it's not unusual that a supervisor may not have contact with the parent. That's not unusual. Typically, it is that one worker that's assigned to do the case, but they're supposed to be reporting into the supervisor on a fairly regular basis, especially if they get new information or if it's high safety issues.
Okay. Well, I appreciate your time. I guess call you back if we have any more questions, but that was very helpful. Thank you so much.
No problem, and good luck. It sounds like you're doing great work. It'd be great if you could, sometimes I wish we could, on child welfare, spend a day in the life of an advocacy group and the other way around, so we could kind of see a little bit of what's going on and both sides of it, because it would certainly make us more open to understanding. But good luck.
We'd be willing to sit down with somebody, if they ever want to do that. There's several of us all over the state. I'm sure there are people who would be willing to come in and sit down and discuss the reports that we have, if anybody ever wanted to do that.
Well, so what agency, you said, I got your nonprofit, what's the name of the agency?
Right now we're just calling it PAL, Parents Against Loss.
Okay. PAL, okay. Because I know that, have you reached out to, the Prevent Child Abuse Agency? I know they have information and data for some of what you're looking at. So there are some advocacy groups out there that may help you at least get more information. Are you local? Are you in the Wake County area? Because yeah, Wake County's big, and Wake County can feel like most of their cases are stipulations, and I was wondering if some of what you're talking about, if you were referring to them. But I know there's other counties over here.
I'm pretty close to Wake County. Most of them are coming from the outside counties. There might be a few from Wake County, but
yeah. And all counties, we are state supervised, county administered, so every state does it. I mean, every county does it different, and it is hard because judges are elected, so we don't always have influence over some of the positions that judges take, which adds another challenge to the whole system.
But the ones we see is just one family court judge who oversees everything, and I mean, I can see you get complacent in your position, but it's basically just whatever the social worker says right now from every hearing that we've witnessed. You know, it's just the judges representing everything that they recommend, and they're almost untouchable. So
yeah, and in some cases it definitely feels that way. I know that, yeah, there's frustration with decisions that are sometimes made against social workers, that are sometimes social workers go beyond what social workers think is necessary. So, yeah, there's a lot of challenges in this field.
So Prevent Child Abuse is a group you've heard of?
Yeah, well, I got to some different websites. I wish I had a card of, and I don't think I have one. Let me see, that worked. I'll look some cards here quick. No, I probably at home. Someone who worked with Prevent Child Abuse, and they were doing some local work. It wasn't just Wake County; it was all local. But they had some really good, both information that could help you, but also some presentations that may help you get more inside how it works.
Okay, well, let's look into it. Okay, well, thank you again. What was your name again? I'm sorry.
Linda Clements.
Okay. Well, thank you very much, Linda. I appreciate your time.
No problem. And call back if, you get more stuff you want to kind of roll through.
Thank you. Thank you so much.
Okay.
Bye.